Hello, we're by the side of the road. Please excuse the sound of backfire in the background. Paul Harrell joke. Meat target. So there we go. This is going to be exclusively about Second Amendment politics, and this is me gleaning things from a couple of websites that just happen to have most of the same information I was already going to be giving up. But this is a political rant about the Second Amendment and how minimalistic and nearly useless it is because of what happened. This is an origin story thing, and it's going to gloss over a bunch of stuff that comes with a lot of caveats, and I'm not wearing my pimp outfit. Here we go. All rights are only as good as the extent they are exercised in fact or reality and tested by case law. To wit, I will walk into California someday, and I will manually build from water pipes and stuff a .50 caliber machine gun barrel and fire a single shot and then take it apart and melt it with thermite because that'll piss off somebody. Neener, you can't stop me as long as you don't know what happened already 6 months ago. Laws are only as good as you can enforce them in fact and test them in case law. Yeah. Good for the goose, good for the gander. Is there any rule or right in law or in the Constitution that's given the power to be unassailable and immutable and unchangeable on a nearly Moses-level apocalyptic, oh my God, don't touch it factor, and claim to be unambiguous, even though it obviously is, as stupidly as the Second Amendment? How many of you looked up the history of this? The fact is that there's no real true history to it. There's just a bunch of opinions, and the fact that at the time, and I'm going to make an assertion that's backed by what I'm going to present, nobody in the frickin' country gave a shit about the Second Amendment, including the people who made it. It was an afterthought. It's an amendment. It is not a part of all men are created equal and they can have a gun. That was not done. This is an afterthought by definition. Don't like that answer? I'll repeat it. Like most rights, it's not unlimited, and it is not really a right if it is limitable or changeable. It is not an immutable or human right to have the right to keep and bear arms. This is a legislated, enacted by our representatives without us voting en masse rule that was established for a specific set of reasons, and ignoring those reasons is what both sides do. Orange tiny hand in the air, waving like tentacles. 1689. Yeah, I'm going way back. The English Bill of Rights, someone wrote this up and commented on it, supported the natural rights of self-defense. You have the right, and the right of the people to self-defense of their life under all conditions shall not be infringed. Is that in the Constitution? No. Well, deprivation of liberty and no, literally, does it state unequivocally? There is a constitutional amendment presented that says that you have the right to defend your life. Well, yeah, but the sun was in my eyes. Are you arguing the Second Amendment religiously, or tactically, or realistically? The resistance to oppression was guaranteed. What kind of oppression? That's a little vague. Civic duty to act in concert in defense of the state. You must defend your country and your state, your province, your county, and your city against attack from who? It is the duty of all members of all states to be volunteered from birth to defend their home territory, city, county, state, or neighborhood against attack from anybody, even their neighbor, or everybody in the South or the North. Now we go to the Federalist, number 46. This is James Madison's own writings. He's one of the people who's involved in influencing what happened with amendments. A federal standing army could be kept in check by state militias. That would be able to repel the danger of a federal army of regular troops at the time. In case you don't know about this, a federal army now can overwhelm a state militia or all state militias, not by numbers, but by ability. Yes, gun owners in the United States outnumber the military by a bizarrely high number because we have a small, relatively, standing army. Remember, how many people were alive in 1776? So, let's go forward. 1777, under the Articles of Confederation, all states were required to maintain their own well-regulated, disciplined, and sufficiently armed and accoutred militia with a proper quantity of arms, ammunition, and camping equipment, and appoint all officers under the rank of colonel within, and everybody above colonel had to be appointed by the federal government. 1777, this was a ruling about state-run militias made of irregulars, not professional military people, but volunteers or conscripts or people who were drafted to be part of the militia. We now call that the National Guard, even though it's actually the State Guard. Oregon State National Guard, kind of contradiction term. It's the Oregon Guard. The California State Guard. The North California State Guard, because California is really 2 states, it seems. I mean, really, it's huge. The Confederation Congress was permitted to requisition these militias for common defense. The Congress was allowed to collect people from all of the militias or control them partially, only in proportion to the number of white inhabitants in each state. But the Second Amendment is immutable. Okay, so it's only white inhabitants that are allowed to own property, and you can't vote unless you're a property owner. All of you poor people are barred from voting from now on. Hillary becomes president. Again, do you want to mutate or alter the Constitution and the rules in it? This is part of the Constitution. When it's convenient for you or not. You aren't allowed to have these arguments because I'm going to tell you about something. The Second Amendment did not apply to individuals having gun rights until excruciatingly recently. And I'm going to show you why. Again, all rights are only good as the extent they're exercised and tested in case law. Same thing with your rights. You claim that this is an unambiguous right to keep and bear arms shall not be infringed for people. Let's see how long it takes for them to bring up people instead of just talking about the militia. Congress couldn't declare war, raise an army, appoint a commander-in-chief of the Army or Navy, unless 9 out of the 13 states originally decided to say yes. Arms and military power remained solidly in state hands, because that was practicality. The Confederation government taking over only in dearest circumstances after asking the states for permission very humbly. This was a states' right-based thing in 1777 and did not include the Second Amendment. You are talking about your founding fathers not giving a shit about your individual gun rights or even mentioning militia gun rights. At this point, 1787, 10 fucking years later, the Constitution being made. Now, the president was the commander-in-chief by default. The Congress had to train, arm, and control state militias. They had the power to call them into service, raise an army, declare war, and all using simple majority. They didn't have to get state permission, consultation, or a majority of more than a certain number of states or a certain number of delegates. Now we're talking 1787, before the Second Amendment was created. And it would have forbidden Donald Trump from launching a war or building a fucking wall. Again, do you want to go, how far back do you want to go for it to be convenient for you, but not inconvenient? Again, you still don't have the right to vote unless you're a house and landowner and white and male. Bitch. Reserving to the states, respectively, the appointment of the officers below a certain rank, authority of training the militia, as well, adjunct, according to the discipline prescribed by Congress only to repel invasions, execute the laws of the Union. Federal law had to be enforced by your local militia. They can't disobey the federal government. Still can't. And suppress any insurrection, aka the South isn't permitted to rise soon enough. Again, how much of the Founding Fathers' will, we're now 10 years on, do you want to ignore so you can keep your morality and ideology active in the comment section on the fucking internet? Just attack the shut up on a tree as free speech anonymously posted. This officially said that rebellion is illegal. And it would be done by the militia that would be given the right to keep and bear arms. Let's listen. A standing army of the professional soldier swarming in to enforce tax laws, crush rebellions or revolution, or confiscate your arms was authorized at this point. Again, Constitution. It's a right under the Constitution. Not yet. Federal government can now control everything, every aspect of the military as far as it's structured during war or peace, and dominated all states in some ways. 1788, 1 year later, Constitution ratified in this condition, without any amendments or argument, by 6 out of 13 states effectively: Delaware, Pennsylvania, New Jersey, Georgia, Connecticut. Massachusetts ratified, but attached a list of amendments proposed. Pennsylvania hadn't done it yet, but it did it eventually, and it had 15 amendments it wanted to do, including, and this is the only one on record, it wanted to include the right to be armed for the people or the militia or both. It is the one that brought it up. This is 1788. Again, which version of the Constitution do you say is the one? It's the one I like best. Then that means you're not talking about a human right because you're picking and choosing. Stop quoting it like the Bible and misusing it like the Bible, please. Members of Congress were attempting to reassure the states later on that they could retain their militias and that Congress could not disarm them by creating the Second Amendment. This is the intention almost all of the people who were delegates that time stated in their memoirs or whatever, because they're self-important assholes. We have these records. A well-regulated militia is necessary to the security of a free state, the state of Oregon or the federal government or whatever. The right of the people to keep and bear arms shall not be infringed, because they wanted to not limit it to just their own standing, quasi-standing militia. They wanted the entire population to be able to have this. But that's your interpretation. I know it is. But that was the interpretation at that moment by the people who fucking wrote the Second Amendment. Now shut up and listen to what was happening later. I'm in favor of the Second Amendment being interpreted as you and me having the right to keep and bear arms and not the military. Shut your mouth and listen. We'll wipe tax talk. To protect rights of the states to arm and maintain an irregular militia of random citizens, that's the reason for the reference to personal possession only. It was an adjunct added in clumsily. It's a poorly written statement. What happened later? No convincing proof that personal possession was intended to be unqualified or the main focus. It was an adjunct onto it because they realized that way they could have an unlimited number of people as long as their state had a population of any kind. 1876, Supreme Court ruled Second Amendment means no more than it shall not be infringed by Congress, has no other effect than to restrict powers of the national government. No one else, state can restrict it. And the right to keep and bear arms is not granted by the Constitution. Neither is it by any manner dependent upon the instrument for its existence. Well, I don't like the Supreme Court, but you're going to bitch about me not including the next one. Supreme Court ruled Second Amendment did not protect weapon types not having a reasonable relationship to a well-regulated militia in 1939. Under the Second Amendment, state analogs as well also made it lawful to prohibit carrying concealed weapons. They had conditions for making, selling, or manufacturing. Prohibitions on possession of firearms by felons or mentally ill, prohibitions on firearms in sensitive places like schools, government buildings, etc., 1940. But the good old days, we could do what we want. No, you couldn't. You were restricted more then than you are now. You do not have a right. The right was not to keep and carry any weapon under any conditions for any purpose at all. It was routinely explained through all of these cases that it was for citizen state militias, our current National Guard, and also could be extended. Until 2016, the Supreme Court did not completely allow it to be for ordinary citizens. It's not the Founding Fathers or their intent. It was a ruling in 2016, 2008, and 2010 that gave you a right you thought you had the entire time, because it's immutable and it's a stupid sentence in one goddamn piece of paper that has been bandied about for decades or centuries, depending on how you look at it, and it was never intended for your purposes. And I'm okay with this current status because this is what we wanted. You won, but it's not from the Founding Fathers. It's from the courts and the legal system, and figure out whether these are Republicans or Democrats that gave you your rights that you thought you had the entire time. Game over. Thanks for watching. Have a good day. Good luck with that.